where you are. And this session will be examining genetic and epigenetic testing as emerging technologies and consider the development of ethical and policy frameworks in this area to ensure the benefits of precision medicine are equally distributed and potential harms are minimized. And in particular, this session presents ethical, legal, and social considerations in developing regulatory frameworks in relation to home genetic testing, human germline gene editing, and the use of big data in genomic research. Our first speaker is Dr. Santa Slockenberger, who asks, will we be healthier in the era of precision medicine? Dr. Slockenberger is a researcher at Uppsala University in Sweden, and her current research focuses on regulating the standards of medical care in scientific uncertainty. Her other research interests include ELSI in human genetics and genomics. She's particularly interested in the governance of the new and emerging technologies in this field, especially the limits of competence and authority, the involved actors and their overlapping competencies. So I'll be playing the pre-recorded presentations from each of our speakers. So please just give me 1 second while I set that up.
Hi, my name is Santa Slockenberger, and today I'm going to talk about human germline gene editing in European perspectives, and more specifically, what would it take to enable human germline gene editing. Until 2018, human germline gene editing was thought to be still quite far from clinical reality. It wasn't so because the technique wouldn't be there that would enable these kind of interventions. There have been different techniques available for quite some time. Some newer ones, such as CRISPR-Cas9, are not only relatively easy to be used, but also affordable, and thus they create better preconditions for enhanced research and eventually care. It was rather because such interventions relate to artificially created heritable changes in the human genome, and they raise profound ethical, social, and legal questions that need to be resolved before this technology could be applied to human germline cells, either within clinical research or clinical care. In November 2018, about 3 years after the first use of gene editing technology in human embryos, a Chinese scientist, Dr. Ha Zhanghui, announced that he has helped to make the world's first genome edited babies, twin girls who were born in that month. The world knows these babies as Lulu and Nana. The announcement that was made provoked shock, even outrage among scientists all around the world. The experiment that was made was deeply unethical, and given the availability of other means for preventing vertical transmission of HIV, which was the particular intervention that was done, they had little to no clinical justification. The international consensus that at this point it would be irresponsible to proceed with any clinical use of germline editing that scientists announced just 3 years before the intervention, that is in 2015, was violated. The critical reactions to the statement made by Dr. Ha Zhanghui are not surprising, and they were not surprising when they first came once the statement was made. After all, in a symbolic sense, human genome is regarded as the heritage of humanity, as affirmed in Article 1 of the Universal Declaration on the Human Genome and Human Rights. And any intervention in the human germline has a direct impact on future generations, and that needs to be given due regard under Article 16 of the UNESCO's Declaration on Bioethics and Human Rights before the intervention happens. And we know it had not happened. The technological developments that occur in the area raise high expectations for clinical applications for both for somatic gene editing and germline gene editing. They have the potential to shape the therapeutic landscape of genetically defined diseases and enhance the field of personalized medicine. And if the technology is shown to be safe and effective, clinical germline gene editing could have also distinct important benefits. There are two possible applications that are widely discussed. One is infertility treatment. Gamete gene editing could be an option for parents suffering from genetic infertility. The other option that is discussed is disease prevention in the future child, and it could be this technology could give possibility for prospective parents who are at a higher risk of, for example, having a child affected by a serious genetic disorder and for whom pre-implantation genetic diagnosis is not a real option, to be more confident they will have a healthier child. The technology as such, however, is not restricted to clinical potential only and could be used without any medical indication, such as for pure enhancement purposes. In the last years, several policy responses have emerged, and some of them are overlapping, others point in rather different directions. And just to illustrate, there are some who are suggesting moratorium on pregnancies from edited embryos, as human germline gene editing is not ready for clinical use. There are opinions that split on the continuation of research. Some suggest that research in order to gain knowledge should continue. Others emphasize that research should not continue as there is no potential for clinical utility, or the clinical utility is expected to be very limited. Although commonly it is emphasized that any translational research should be confined to therapeutic applications, there are also some rare voices suggesting that continued work should also be made in regard to possible permissible uses of human germline gene editing for non-therapeutic purposes. And there is rather consensus that human germline gene editing is a matter of important societal concern and adequate discussions are needed. If the technology at some point is regarded as safe and effective and ethical dilemmas are resolved, can we apply this intervention in clinical research and clinical care? What does the law say? Well, if you look at the international fora, what we see is that human germline gene editing is vaguely regulated. We do not have an internationally binding treaty that would address the matter and would bind all the countries across the world. Only Universal Declaration on the Human Genome and Human Rights, in a rather vague manner, gives attention to the matter. In Article 24, it states that germline interventions could be contrary to human dignity. In Europe, both regional legal orders take a more stringent position. To begin with, the Council of Europe, in its Biomedicine Convention, has set forth a ban on introducing any modification in the genome of descendants, and it's intended to cover any intervention on gametes or on embryos if used for procreation purposes. It does not preclude carrying out research that does not involve procreation attempts. What's interesting with this provision is that this article doesn't rule out interventions for somatic purposes that might have unintended side effects on the germline. And those countries that have acceded to the convention are, of course, expected to follow this ban, and they are accountable for compliance. If we're looking at the European Union, then the question of clinical trials is a field of EU competency, and there the member states have been preempted from action insofar as the European Union has regulated the matter. Here, clinical trials regulation applies to all trials conducted in the European Union, and it requires that any trial is authorized in accordance with provisions set out in the regulation. And Article 90 says that no gene therapy clinical trials may be carried out which result in modifications to the subject's germline genetic identity. And a similar provision was enshrined in the old framework, the Clinical Trials Directive. On top of that, in the Charter of the Fundamental Rights of the European Union, in Article 31b, we can find prohibition of eugenic practices. What this really means and what implications it has for human germline gene editing is not fully explored yet, but it could have implications regarding the possibilities to rethink the legal framework. One could say that, and there are some who argue that bans such as those set forth in the Biomedicine Convention and clinical trials regulation sit very well with the principle of human dignity. But there are also some who argue that the very opposite is true. The principle of human dignity would require that interventions, if they are deemed safe and effective, are made available and alleviate humanity from sufferings. And human dignity, among others, is a right set out in the Charter of Fundamental Rights of the European Union, Article 1. If we assume for a while that there is interest at some point and willingness to enable human germline gene editing in Europe to take place as part of clinical research or care, one could question how should we go about it? How, if at all, these bans could be lifted, and must both of the bans be lifted at the same time? So, and if you look at the Biomedicine Convention to begin with, it is an international treaty that is concluded under the auspices of the Council of Europe, and an international treaty may be amended by an agreement between the parties. The Vienna Convention on the Law of the Treaties, which is a treaty governing treaties, allows that treaty amendment rules are set forth in the treaty itself. So to say in Biomedicine Convention, and that is what is done. Article 32 sets forth a 4-stage mechanism to make the amendments happen. To begin with, we need to have a proposal in place, and the proposal may come from a party of the convention, the Committee on Bioethics, or Committee of Ministers. Thereafter, it needs to be examined by the Committee on Bioethics. In this committee, each member state of the Council of Europe and also the member state of the convention, should there be any who is not a member of the Council of Europe, the Council of Europe may be represented, and each party who is represented then has one vote. If the proposal is approved, it proceeds to the next step, to the Committee of Ministers for their approval. And the Committee of Ministers is the organ that acts on behalf of the Council of Europe, and there each member of the Council of Europe is entitled to have one representative of the within the Committee of Ministers, and then each representative again is entitled to have one vote. And here there is quite a high voting threshold in place. If you look at the previous step, Bioethics Committee, there is required that 2/3 majority of the votes is in place. And then if you look at the Committee of Ministers, then what's required there is a 2/3 majority of the representatives casting a vote and a majority of the representatives entitled to sit in the committee. And only once these steps are passed, the text of the convention, the amended convention, may be forwarded to the parties for ratification, acceptance, and approval. In other words, one could say that there must be considerable interest in furthering the changes, and this interest needs to come from different directions and reach considerable threshold. Firstly, there needs to be a majority of the member states experts working at the Bioethics Committee in favor of the changes. Secondly, it needs to pass the threshold assigned to the Ministers of Foreign Affairs sitting in the Committee of Ministers. And only thereafter there is ratification, acceptance, and approval. So let's look at the European Union. What has happened there, and how could we think of lifting the ban within the clinical trials regulation? Clinical trials regulation is adopted in line with the ordinary legislative procedure. Any amendments need to follow the same procedure. This means that the European Commission holds the lawmaking initiative. The task of the Commission when initiating lawmaking is to promote the general interest of the European Union and take appropriate initiatives to that end. In other words, only when the European Commission believes that lifting the ban on human germline gene editing is of the European Union interest, the Commission may prepare a corresponding proposal. Who is sitting in the Commission? Well, at this point, we have one representative per country, but it's required that they are completely independent and they shall neither seek nor take instructions from any government or other institution, body, office, or entity. Thereafter, once the Commission puts forward a proposal, it needs to reach an agreement between two central actors in the lawmaking procedure, the European Parliament and the Council. And that can take up to 3 stages. The European Parliament is composed of the representatives of the Union citizens, and it acts in the interests of these citizens. So to say, when the Parliament regards the intervention to be in the interests of the citizens, it's expected to act accordingly. And the Council also needs to agree, and the Council is the one who has policy-making powers within the European Union. And members of the Council are members from governments of the member states, and they are explicitly allowed to seek instructions from the member states. So to say, also the member states need to be on board in rethinking the ban set forth in clinical trials regulation. One could say that There must be considerable interest in furthering the changes, and this interest needs to stem from different directions and reach considerable threshold. There needs to be an interest from the European Union for this to happen. There needs to be support of the people's representatives and the member states. So, what does this picture tells us? Both legal orders set considerable thresholds for human germline gene editing to enter into the domain of clinical care. At the same time, neither of the two bans is set in the stone. There are procedures for amendments that could be put in use, and these bans could be lifted. Similar to both processes, it's that they require considerable agreement between different representatives of the member states wearing different hats and those belonging to representing the involved institutions or people. There is room for tensions to emerge at the member state level and between different actors within the member state, and between different states and between different states and institution representatives. So theoretically, there is a possibility to lift the bans within each of the legal orders, and there isn't any requirement that it needs to be done simultaneously. It is, however, I would like to argue, neither practical nor sustainable from the state external accountability point of view that it is not done simultaneously. Council of Europe and the European Union share the same set of 27 member states, even though the total number of the members of the Council of Europe is 47. Not all member states are parties of the Biomedicine Convention, but a significant portion is. That risks resulting in a situation where a state has conflicting legal obligations. Some conflicts can be easy to resolve, some are not as easy to be resolved. For example, if the Biomedicine Convention lowers the standard and the EU retains it, then member states have a chance to envisage a higher level of protection, and that will be in line with the Biomedicine Convention. So this conflict could be resolvable. However, if the European Union lowers the standard, a question emerges whether it would then allow the member states to retain higher standards to remain in line with the Biomedicine Convention obligations. On the one hand, it's a question of moral values, where the EU has been generous in leaving quite some leeway to the member states. On the other hand, this matter will eventually end up being a market question, which then is of the European Union's interest. Additionally, considering the free trade and free movement, there could be rather limited effects of national unilateral exemptions, should they be allowed. And this could suggest that the question of human germline gene editing is a European concern, and we need fruitful multi-level policy discussions in addition to the dialogue with society and stakeholders. Thank you very much.
Thank you so much for that, Dr. Slockenberger. Really fascinating presentation on regulatory frameworks around human germline editing. So we'll continue with the next presentation, and we'll have questions and discussion at the end. Our next presenter, unfortunately, isn't able to be with us today. He's unwell, but he is Dr. Jordan Parsons, who's a PhD candidate at Bristol Medical School in the UK. His doctoral research concerns best interest decisions in nephrology, with a particular focus on dialysis. Alongside his PhD, Jordan is currently engaged in a body of work exploring the potential role of telemedicine in the provision of early medical abortion. His book on this, Early Medical Abortion, Equality of Access and the Telemedical Imperative, will be published later this year with Oxford University Press. Jordan's other research interests lie in organ donation and transplantation ethics, HIV prevention, genetic privacy, prisoner health, and telemedicine. And I'll start Jordan's recording now.
Hello everyone, so I'm Jordan Parsons and I'm based at the Bristol Medical School in the UK. Today I'm going to talk a little bit about some work that I've been doing on obligations to inform in the realm of direct consumer genetic testing. And so this is work that was published in late 2020 in the Journal of Medical Ethics. And so just a quick thanks to Philip Baker, my colleague with whom I did this work. So just a brief overview then of what I'm going to cover today. So the central question in this paper was whether or not there is an obligation to inform genetic relatives of actionable risks that are discovered through direct-to-consumer genetic testing. So today I'm going to demonstrate then why we think the answer to this question is yes, how we think that this should play out in practice. And so I'll propose our system of preemptive consent, which is then followed by the sharing of information in a maximally identified form and through a stepwise communication of risk process. So just to quickly set up the topic and some parameters of what we're talking about. So we're concerned only with the direct consumer genetic testing, so otherwise known as home genetic testing. So this is outside of the clinical context and where those that are being tested are to be considered more as consumers than patients. And this is something that there's been exponential growth in recent years. But that being said, it does remain a largely unregulated space. And so people are basically able to access these services really quickly through just online purchasing, and there's no real counselling or follow-up processes in place. And a study that was done in 2011 found that really the motivations and expectations of a lot of consumers that are accessing these services are somewhat health related. And so even though there are often disclaimers by the providers of these tests that results should not be used to inform any decisions about your health, it appears that this doesn't really align with the realities of what the consumers are taking from it. So our argument really begins with Parker and Lucasen's proposal of a joint account model for genetic information. So they hold that genetic information is just familial in nature and that can't be escaped, and that this doesn't really align with the prevailing personal account model that we have. So the personal account model is understandably based on ideas of autonomy and confidentiality, but tensions arise here in genetics when it comes to the interests of others being at play as well. And so Parker and Lucasen propose thinking of genetic information instead as something like a joint bank account. So whereas no individual account holder can request that a bank manager withholds information about the account from the others, so can it play out in the context of genetic testing. And so then this would shift the burden to the person who wants to exclude family members from access to genetic information, as we're starting from this understanding that it should be available to all concerned. And so unless the proband can demonstrate that the relative does not stand to benefit from the information, then really that sharing should be deemed acceptable. So ultimately we adopt this position as we think that it does really speak to the reality of genetic information as shared, as well as recognizing that the harm to others, so the relatives of the proband, really should be factored in, and that it can't purely be about the autonomy of the proband in this context. And so there is then a right of the relatives to know, and as such there must be a corresponding duty to inform somewhere along the line, which we'll come to shortly. The joint account model then holds that sharing information is justified if there is a sufficient benefit to the relative. And so what makes that benefit sufficient? We draw this line between actionable and unactionable risks. So first to actionable risks, which are essentially those where there is some kind of risk reduction strategy available to someone. So for example, with the BRCA1 and 2 gene mutations, there are often risk reduction strategies available. And whereas these might be profoundly unpleasant in some circumstances, research has indicated that people do consider the ability to take action as a critical factor in whether or not they would like to know. And as such then, an obligation to inform in such circumstances, we suggest, can be rooted in what's called the rule of rescue. So when Johnson outlines the rule of rescue, it's really about this natural response to imminent death. And as such, it is often formulated in terms of things like burning buildings and people drowning. And Singer adds to this an important caveat, which is that the rule should only apply where nothing of comparable moral importance is being sacrificed. And this we'll return to in just a moment. So Kilbride has sought to apply this rule of rescue in genetic testing, but placing the obligation on the proband themselves. And this has been criticised based on the fact that the risk is not sufficiently imminent. And so this is why we think Singer's caveat is important, as essentially we can just raise the standard where that risk is less imminent. So we can also factor in, for example, the potential distress to the relative, and then weigh this against the potential harms of the disease and the extent to which that can be mitigated. And nonetheless, we would depart from Kilbride on practical reasons, instead saying that we would be better placed having the provider as duty bound, as realistically you cannot enforce the proband telling relatives, so it's essentially pointless having a duty if it's just on them. And so in summary then, where the relative can be rescued, we suggest that a duty on the provider arises to inform that relative. Now to unactionable genetic risks then. So in such circumstances, it is less clear that the relative is going to benefit from knowing. So the rule of rescue may not be engaged. Of course, the reality is that some would still want to know. So we know that often people who are motivated to access direct-to-consumer genetic testing are doing so because they really just want to know everything that they can about their health. And so even though they haven't accessed the tests, that might apply to the relatives too. But here we'll return to Singer's idea of comparable moral importance and bring into the fore the idea of non-maleficence. And so where the benefits are unclear in informing the relative, but there remains this possibility of distress to them, potentially even damage to family relations, we suggest that something of comparable moral importance is being compromised here, and as such, this duty coming from the rule of rescue cannot be said to arise. And so, if only when something is actionable does this arise, the question I suppose remains as to what exactly actionable is in terms of how we can quantify that in establishing whether the provider has this duty. So this needs to, we suggest, account both for the severity of the disease in question, as well as the relative risk reduction that is achievable. And essentially this can sort of be combined to create some sort of condition-specific score, and then a provider is only really required to inform the relative where that score is passing a certain threshold. So I won't dwell on any attempt at calculations here, as this is obviously something that would vary hugely across jurisdictions and would have to be figured out by the appropriate people. But we just present this as at least a potential way of trying to distinguish between the two in practice. If the decision is then made that information is to be shared with the relative, an inevitable question is arising as to whether this is a breach of confidentiality, if the proband is there opposing the sharing of that information. This becomes particularly problematic if this question does not actually come up until the test results are in. And as such, we suggest that some model of preemptive consent would actually help avoid these problems. So essentially, we could make a situation whereby testing is contingent on the consumer consenting not only to the testing, but to the possible eventualities. So they can be made aware of the information that would be shared, who it would be shared with, when that would happen, and how that would take place. And then it will be required for the consumer to consent to this before any testing can take place. Now, arguably, this will appear at odds with our common understandings of consent as something that can be revoked at any time. But we do suggest that this is something that really should have limits and arguably has a precedent in research. So there is generally a point in the research process where participants can no longer withdraw their consent to the use of collected data because it's simply not possible. And we think that this can mirror quite nicely in the context of this direct-to-consumer genetic testing, particularly given the de-identification of information that I will come to shortly. And we especially think that this is appropriate given the balance of benefits and harms that I earlier mentioned. So where we allow consent to be revoked in a clinical setting, the impact is ordinarily only on that individual, but in this context, others are affected by it. Even with this preemptive consent in place, it is obviously important that information sharing is done appropriately. And we suggest that this can at least begin with maximal de-identification of that data. And so where the proband is opposed to the sharing at the time, it acts as a sort of quasi-protection of their autonomy. And so this requires the distinguishing between the familial and the individual information, with only the former being shared. And so no explicit information about the proband should be provided. Reasonable efforts should be made to ensure that it is not clearly discoverable to the relative. There are, of course, some issues here, particularly in that in a smaller family, perhaps it might be far easier for the relative to figure out who it is that must have been tested. But this is simply something that the preemptive consent process can make clear to the proband. So they are accepting the risk that their family could discover who they are, even though their name isn't shared. Someone might also raise the objection of this whole damage to the relationship between the proband and the provider. But because this is direct-to-consumer genetic testing, this is more a matter of consumer distrust rather than distrust in the health profession itself. So we don't consider it to be problematic. So as much as I've talked about this right to the relative to having this information, there is also this recognizable right of the relative not to know this information. And so the relative does need to have control over how much information they receive to protect their own autonomy. And as such, we suggest that a stepwise communication process should take place. So at first, the relative can receive some really fairly generic correspondence to say something along the lines of, your relative has been tested. There is reason to believe that you may also be at risk of a certain disease, but without naming that disease. And that risk might be reduced through certain actions on the relative's part. So as I said, information on the disease in question should not be provided, nor should any stats about their increased risk. And then the relative can really make the decision for themselves as to whether they want to know more about this. So they can either just find out about their risk themselves, particularly relative to the population, or they might want more detailed information about what they might do to mitigate that risk, which would obviously include themselves getting tested to confirm things. And then equally, if they simply don't want to know, they can disregard that letter entirely. This obviously would require having the contact information of these relatives. And as such, we suggest that in that preemptive consent process that I've already outlined, this can be captured almost like contact tracing, which we suggest should go as far as first degree relatives, essentially to avoid being unrealistically cumbersome to people. There is obviously a risk that this information could be falsified. It's also possible that estranged families simply will never find out these things. These are simply, I suppose, the realities of it, and we suggest that at least the duties of the provider are at least met by them using the information that the proband has provided. So it would not be realistic to expect them to then go and somehow chase up the information and track down these relatives to inform them of things. So this is a flow chart that we put together for the purposes of the paper that this work is in, and just to sort of visualize the process that we envisage. So please feel free to pause here if you want to take a closer look at it. In conclusion then, we suggest that there ought to be a duty on the providers of direct-to-consumer genetic testing to inform the relatives of probands of actionable risks where they are discovered. And so a process of preemptive consent should be followed initially, and that can really set things up before the testing even takes place. Appropriate information should then be shared, by which we mean only that which is familial and not individual to the proband. And so then that also would include the maximal de-identification and the stepwise communication of risk process that I outlined. And so then this system would also generally be encouraging more accountability on these providers of direct-to-consumer genetic testing, which we suggest is something that is much needed. And it might also encourage more pre-testing reflection on the part of those who are seeking out these services. Whereas currently it's quite a quick process to buy something. If you've got to go through this preemptive consent process, which would make clear to you potential risks of your relatives being informed, it might make people reflect a bit more and consider whether it's something that they really want to be doing, which again is something that we suggest is quite important. And then just at the bottom there, that's just the citation for the paper that I mentioned, which this is all outlined in. So feel free to take a look if you're interested. So thank you for listening, and I look forward to discussion and meeting you all at the workshop. Hello, everyone.
Okay, thank you to Jordan for that. And again, unfortunate he's not able to be here with us. And next up is going to be Professor Jeff Craig. And Jeff is a lecturer in medical sciences at Deakin University School of Medicine. He researches the role of epigenetic states in mediating the effects of early life environment on the risk of neurodevelopmental disorders, such as autism, ADHD, cerebral palsy, social anxiety disorder, and developmental coordination disorder. He's a chief investigator on the NHMRC-funded Twin Center of Research Excellence and president of the International Society for Twin Studies. He has a keen interest in public engagement, and in this capacity, he leads the cross-faculty Gene Equality Deakin University Research Network.
Hello, my name is Jeff Craig, and I lead the Gene Equality Research Network at Deakin University. I'd like to acknowledge my colleagues in the Gene Equality Group, Evie Kendall, Nira Bhatia, Maurizio Maloney, and newly joined the group PhD student Laura Azevedo. And today, I'm asking, how similar are the technical, legal, and social issues related to genetic and epigenetic testing? First of all, I'd like to thank all those whose work I talk about here and provided plenty of inspiration for this talk. I'm going to split the talk into three parts. The first will be what we know and what we don't know about epigenetics. Secondly, a summary of clinical versus direct-to-consumer epigenetic testing. And finally, comparing technical, ethical, legal, and social issues of genetics versus epigenetic testing. So first of all, what we know and what we don't know about epigenetics. We know that epigenetics is a combination of synergistic marks. Those marks include DNA methylation, various histone modifications, and non-coding RNA, which is sequence specific. And together with additional factors, epigenetic marks form a 3D structures. And these enable coordinated control of gene expression throughout the cell nucleus through development and over time. So we know that epigenetics can be a fixed memory of a developmental event. For example, as you can see on the right, this picture represents development into various different cell types and tissues prenatally, but also epigenetics can also change over development as well. It's related to aging. We now know through the epigenetic Steve Horvath's epigenetic clock that epigenetics does change over time. So it's both a fixed memory of a cell type, specifying cell type, but also changes over time. So we know that depending on genomic location, epigenetic state is always influenced by these three factors. Firstly, genetics, genetic sequence. Secondly, environment. I've shown two examples here of smoking and stress, which are external environments. There's also internal environment, which includes hormones traveling around the body, turning genes on and off. And finally, the third component is development, which includes stochastic processes, especially in very early life. And this really, as I've said, depends on genomic location and timing. So what do we know about epigenetics in human disease? Well, it all started with cancer. Cancers we found are generally very epigenetically different from normal tissue. If we're talking about DNA methylation, where we're looking at a scale from 0 to 100, often we see 80 to 100% differences in DNA methylation. Easy to spot. And this being easy to spot and easy to measure has resulted in diagnostic and prognostic tests that are in the clinic, together with epigenetic therapies, which have been in trials for the last 10 years. In addition, there are also precancerous epigenetic states, and some of these have been are in trial for predictive testing for various cancers. Outside cancer, into chronic diseases, non-Mendelian disorders. These studies are plagued by a number of factors, including small effect sizes, so less than 5% is typical effect sizes in these studies, small sample sizes, meaning less than 1,000 individuals, lack of replication, lack of causative models. Most epigenome-wide association studies are associations. And also we have to deal with a number of confounders such as genetics, cellular heterogeneity, which is a big confounder, which means any given tissue, for example, blood, is composed of multiple different cell types, each with a slightly different epigenetic state. And also there's technical confounders such as microarray batch. And to my knowledge, there's currently no clinical tests for chronic diseases based on epigenetic state. So next, about what do we know about human environments? Again, we know that there's small effect sizes, and there's very few human environments for which the epigenetic associations have been replicated in meta-analyses. And some of these include generally smoking, stress, and in a limited way, alcohol exposure, plus the Horvath and other epigenetic clocks that, which show a coordinated change of certain regions over time. That's also been replicated as well. So next section introduces clinical versus direct-to-consumer epigenetic testing. This is a table from a recent review about tests that are in the clinic for cancer. And I've highlighted with the red box colorectal tests for colorectal cancer. And you can see that there's various single gene tests measuring DNA methylation, plus there's a microRNA test. And the biospecimens tested include stool samples, cell-free DNA from blood, and formalin-fixed paraffin embedded sample. So these are, and more are in the clinic. However, direct-to-consumer epigenetic testing is way behind. And there's been a lot of hope and discussion, or some discussion about whether epigenetic tests are ready, but there's been a lot of hype based on very limited data, and we have claims that autism can be detected in saliva. Then you've got Alzheimer's, you've got skin care, skin health, infertility, and a lesson down the bottom in red is that Ubiome has recently been charged with defrauding investors to the cost of $60 million because simply their tests weren't scientifically valid. We must be careful of this. So now to compare the technical, ethical, legal, social issues of genetics versus epigenetic testing. So I'll go through each of the TELSI in turn. First of all, looking at what's similar and what's different between genetic and epigenetic testing. So similar between genetic and epigenetic testing is, as I've just mentioned, they have to be scientifically sound, they have to be replicated. Secondly, they have to be analytically valid, which means can the test measure what it's meant to do? Second, they need to have clinical validity, which means how well does the measured variable reflect specific measures of health? Clinical utility, also, which means how well can the test results inform on diagnosis, treatment, and management and prevention? Is the test specific for certain individuals and specific for individuals in general or groups of individuals? There need to be specific regimes for implementation and regulation. And we also need to ask, is there a better way other than an epigenetic test of assessing risk for a particular condition? So what's different? What technical issues are different about epigenetics? Well, the statistical models may differ. The more continuous variables in the primary data, statistical models, are therefore different. The reference data may require specific tissue, a specific age group of individuals, or even a specific environment or timescale of exposure, or even a timescale of prediction. Can you predict, for example, in young individuals compared to older individuals? And yes, I'm reminded that we often use proxy tissues needed for inaccessible organs, such as the brain and the cardiovascular system. And we must beware of cellular heterogeneity, as I've previously mentioned. It can skew results. So what else is different? Well, it's a warning that we mustn't extrapolate from animal to human studies. It's also because epigenetics changes over time, we may need to repeat certain tested intervals to reflect changing exposures or changing risks. The actionability can depend on the window of development opportunity. Incidental findings, for example, could reveal past toxic exposures. What would happen then? Would we have a duty to report those? And of course, there's no single healthy reference epigenome. Ethical issues, what's similar? Well, the similar issues, of course, do patients understand the test they're undertaking? Are they assured that their data is being kept private, not sold off to anyone? We have to be careful of specific consent for future testing. There are, of course, implications for family members in both sets of tests because of the genetic influence on both. And of course, both have the potential, the knowledge of genetic and epigenetic status, potential for discrimination by employers, by society, and by insurance companies. Also, with direct-to-consumer testing, there is generally no access to a medical practitioner for advice or even a counselor to talk about the results. And often we have overdiagnosis, which means conditions that won't harm people. And it's also been discussed, for example, that conditions such as Down syndrome, autism spectrum disorder, and deafness are classed as differences rather than afflictions by some people. And of course, there's a danger of selling false hope via hype. So what's different about ethical issues? Well, with regards to privacy, you could identify current and past environments. Some of the environments that you may consider private, past smoking, past drug use, for example. There's implications for those who share the same environment. So that's equivalent to the families with genetic testing. If you live in a certain community where the epigenetic test showed you were exposed to a certain toxic substance, then the other people living in that area may have a duty to be told. And people have discussed the idea that you are responsible to change your results, which is not always possible. And it's also been discussed whether human rights can ever be eroded. And an example is that has been the discussion of whether groups of young immigrants should be epigenetically tested for epigenetic age to prove that they're under 18. On to legal issues, what's similar? So we know that always the law lags behind medical science, and that the legal frameworks for data breaches are constantly evolving. And if testing can lead to discriminatory outcomes, will there be a need for a legal redress of this? And also there's the issue of disclosure of information to families. And it's being discussed that previous tests may lead to medicalization of normal people. People who have a risk but don't show overt phenotype of the disorder being labeled as sick. The legal issues that could be different with epigenetic tests. First of all, are there general cautious duties that apply duty of care not to cause harm? There's a disclosure of information to those with a shared environment, which I've mentioned before. Potentially with forensics, we can now tell, for example, if the suspect was a smoker or even sometimes a previous smoker. And with crime, the usual arguments may come forth that my epigenetics made me do it. Onto social issues, what's similar between genetic and epigenetic tests is that stigmatization of individuals as damaged. If there's something wrong with them, if they have a positive test, even if it's a predictive test. There's also the phrase financial burden. How would individuals feel when a test was done and they hear that the costs are associated with the financial burden? There's also an issue of equity of access to testing and cost of testing, and associated healthcare and social support. New social issues that have arisen with epigenetic testing include blame. Individuals have been blamed, parents have been blamed, especially mothers, but society could be blamed, but so far there's been more blame on the individuals. The idea of acquired inferiority has been raised, which means when a poor environment is associated with a race or other disadvantaged groups. So this could lead to racism and other discrimination. Agency versus structure. Many papers mention choices or lifestyle choices, but many people don't have this. It's about individualized welfare versus socialized welfare. We should be supporting those who are disadvantaged rather than putting the onus on them to heal themselves. We need to avoid environmental determinism, always saying that epigenetics is always influenced by environment, and therefore this is destiny. We need to watch out for the possibility that employers and others would demand or require repeated tests to monitor employees, for example, their environments such as smoking, drug taking, etc. And also the issue's been raised that studying epigenetics reduces complex social problems to simple molecular codes. So what we recommend and what others have recommended is responsible innovation. What does this involve? Well, we have to ask ourselves as researchers, to what end is our research? To what end is the epigenetics research that we're doing? What test is at the end of it? Who will be disadvantaged by this test? What could possibly go wrong when this test is released? How we can responsibly report our findings, how to avoid both genetic and environmental determinism and reductionism. Remember, we're a product, epigenetics is a product of those three factors. And there is a collective responsibility. This is a concept in which individuals are responsible for other people's actions by tolerating, ignoring, or harboring them without actively collaborating in these actions. And again, thanks to all who inspired our discussions. Thank you.
Thank you so much for that, Professor Craig. Really fantastic presentation. And we have our final presenter, Dr. Stephanie Dyke. Dr. Dyke is a biochemist who has worked in bioethics and science policy in Ireland, the UK, and Canada. She has a current focus on open science and the governance of research data in genomics, epigenomics, and neuroscience. Dr. Dyke joined McGill University in 2014, where she has been conducting ethics and policy research, focusing on data sharing policy with large international collaborations, such as the Global Alliance for Genomics and Health and the International Human Epigenome Consortium. She has worked for a National Bioethics Advisory Council, the Irish Council for Bioethics, as policy advisor at the Wellcome Trust Sanger Institute and at the Francis Crick Institute. Thank you so much, Stephanie, and I'll start your presentation.
Good morning, good afternoon, or good evening, everyone. I'm Stephanie Dyke, and I'd like to thank the symposium organizers and the Brochet Foundation for the opportunity to present today. I'm going to focus on developments in open science in epigenetics and precision medicine, which are really forcing the research community to reassess some of the basic ELSI of research in genetic medicine, with, on the one hand, great opportunities to improve the research process for everyone involved, and on the other hand, a number of challenges. Open science and data sharing policy are particularly relevant to big data projects, which have become one of the main strategies for scientific programs that aim to advance the goals of precision or personalized medicine. So analyzing whole genomes or genome-wide epigenetic variation, along with other big data such as detailed health information or brain scans, is becoming more and more commonplace for very large groups of individuals. The Big Brain Project images shown here are actually a 3D digital reconstruction of brain histology, but these kinds of maps are enabling the analysis of a wide range of brain imaging studies. The Human Genome Project paved the way for widespread adoption of data sharing policies in genomics and inspired seminal declarations on public access to research data by international organizations such as the Organization for Economic Cooperation and Development and the G8. The term open science refers not only to data sharing policy, but also to the open sharing of research methods, research materials and software, of publications through open access mechanisms, and even potentially to the sharing of IP and commercialization efforts. I just want to quickly mention that current developments in clinical trials data sharing are creating opportunities for precision medicine and providing another source of big data for research. Just a quick reminder of why data sharing is so important to science funding agencies. This might be a bit of a sunny view of things, but basically sharing data enhances research and research practices, and critically, it accelerates the translation of research into useful products and policies and so on. To use the example of the Human Genome Project again, that massive international effort was successful because data were shared both rapidly and publicly. And I'll come back to the potential for more diversity and open participation in research that can result in a moment. This slide shows more recent examples of international data sharing initiatives that have shown its tremendous potential. The BRCA exchange, which brings together BRCA cancer susceptibility variant data into an authoritative public resource. The Beacon network, which enables discovery of genetic data across connected data resources. The Matchmaker exchange, which is connecting researchers sharing data from patients with rare genetic disorders. The International Cancer Genome Consortium, which has brought together cancer genomes from around the world. And lastly, the International Human Epigenome Consortium, which is doing the same for genome-wide epigenomic data. So hopefully the potential benefits of data sharing are quite clear, but data sharing for open science also raises big ELSI challenges related to consent, privacy, and non-discrimination, while at the same time, I believe, creating opportunities for greater research participant engagement with research and with the results of research. The work I'm going to present on these ELSI challenges for open science was done mainly with the Global Alliance for Genomics and Health, a standard-setting organization for genomic data sharing, and also with the International Human Epigenome Consortium that I just mentioned, and with the Canadian Open Neuroscience Platform. The first area of work I want to talk about is focused on improving and evolving data access models in the context of open science. And by data access models, I mean who can access shared research data and under which conditions. So data access models are really key to both the ethical legal protections that can be applied to big data, as well as to questions of equity and diversity, as well as justice in the scientific opportunities that are created by open science. This figure shows three main models that have emerged in the genomics community. First of all, there's what is typically referred to as open access, whereby anyone with an internet connection can freely access data for any purposes. At the other end, there's what is called controlled access, in which access is granted on a project-by-project basis to approved researchers. And in between is a more recent model we're calling registered access, in which data would be available to all researchers who will have been pre-approved for data access. And while they must respect conditions of access, such as consent restrictions, individual projects would not be reviewed. So it's a restricted form of access like controlled access, but with less oversight of the research conducted with the data by those who are providing access to it. This slide shows the details of controlled access procedures, what is typically checked before granting access. And there are several initiatives, both with the Global Alliance for Genomics and Health and with the International Human Epigenome Consortium, to harmonize and standardize these procedures internationally, given the implications for both research participant and research communities. For example, some of these steps could lead to preferential access for some scientists. Here are the details of the registered access model that is being developed. And I should add, a longer-term vision for this model is to expand access beyond researchers to other groups or individuals that might have an interest in research data, such as medical professionals as shown here, but also to regulatory officials and even potentially to research participants themselves or to other members of the public. Now, to move on to the question of providing adequate protections to shared data without unnecessarily limiting its use, or in other words, which data access model should be used for which data. There are consent-based restrictions, which I'll come back to in a moment, as well as other conditions of access that can have an impact. But essentially, the decision about which data access model to use depends mainly on two rather complex criteria. The first is, how likely is it that data could be traced back to an individual research participant? And the second is, what might be the harmful consequences of data misuse, especially if it were to have been re-identified? The first issue of possible re-identification of open science data, even once it's been stripped of any obvious identifiers, has been a bit of an ongoing saga in genomics. And I show here a recent example of a criminal being identified through his relatives' DNA sequences that were available from genealogical databases, as well as some of the major publications on identifiability risk in the table below. Identifiability can be a concern with epigenetic data too, and in the example shown here, DNA methylation data can reveal DNA sequence information. In collaborating with scientists working with the International Human Epigenome Consortium, we developed a filtering method for DNA methylation data to reduce its re-identification risk. And we also recommended points to consider for rare disease health data that might be shared with the methylation data and which could also increase its risk of re-identification. And I'd like to give a quick shout out to Dr. Warren Twang, who worked on the filtering method. After identifiability, the second big issue to consider in decisions about which access models to use is what I'll refer to loosely as data sensitivity, by which I mean the potential for harm if data were misused or re-identified. And I've done some work trying to break this down for different types of data, both from examples like the one I just mentioned with methylation and rare disease data, as well as by taking a broader look at special categories of sensitive data in data protection law internationally. And the aim of this work is to produce something like a data sharing privacy test to help assign data to the right level of protection and the right access model. Now to turn to consent and consent-based restrictions on the use of shared data in open science. Instead of consenting to participation in a specific genomic or epigenomic precision medicine study, participants will actually be consenting to an indefinite number of studies internationally, usually within the field of research of the original study, collecting and generating and then sharing the data, but also possibly in the case of biobanking initiatives, for example, to research in several different fields through what is often referred to as broad consent. For example, participants may consent to data being used for all health-related research. That understanding by research participants, as well as of the possible limitations to data use that can be in place with the data access models we've just looked at, along with the understanding of the risks that remain, even if they are very unlikely, is a major challenge to consent nowadays. The implementation of consent withdrawal, as well as of any return of results, that is, the return of individual research results that may be of interest to participants, are both also much more challenging in the context of open science. One of the projects I've been working on related to consent addresses another big challenge, which is to provide consent labels that can be attached to shared data to maintain a clear record of consent-based permissions and restrictions on data use after it's been shared. These are called consent codes. The first version was developed based on standard consent procedures in academic genomics research, and more recently they've been expanded to add codes that are specific to biobanking, clinical trials data, healthcare data, as well as provisions in the context of H3 Africa genomic research in Africa. These codes are being integrated into informatics standards and tools to automate data management. And there is an inherent tension between making data as widely available as possible and having all of the codes that are necessary to provide participant protections. In working with H3 Africa, for example, we added an extra code for local data governance mechanisms, namely local research ethics board review of projects using shared data, because although this is not the current norm in other places, not having that code would preclude participation of these African studies in open science. Another area I've focused on with respect to consent, which is very relevant to precision medicine, are requirements in the context of clinical diagnostic testing to enable contribution of genetic test results to public knowledge bases and to data sharing initiatives such as the BRCA Exchange and the Matchmaker Exchange projects that I mentioned earlier. And this is important to achieve a better understanding of the pathogenicity of variants by bringing together evidence from diagnostic testing settings internationally from a diversity of populations. Now I want to talk a little bit about the return of results as precision medicine research continues to advance. While even a decade ago, much of the genomic and epigenomic research was still very much laying the groundwork for a basic biological understanding of life, these fields are now generating more and more health findings that could potentially benefit research participants individually, although it is still very early days, especially for epigenetics. With the International Human Epigenome Consortium, we therefore produced a points to consider guidance document for epigenetic researchers to carefully consider any process for the return of results. And we tried to take an anticipatory approach based on what we've seen in genomics. Additional challenges for the return of results in an open science context is that data may be analyzed by researchers without any connection to participant communities, sometimes many years after the initial study those individuals were involved in. So there needs to be robust procedures to assess, pass on, and then communicate findings, most likely via the original teams and institutions who generated and shared the data. We are seeing expectations evolve quite rapidly for the return of results in genomics, and a stated aim of many precision medicine initiatives is to support participant recruitment for further research based on their molecular characteristics. So it seems to me we're going to see exciting opportunities to have much more dynamic interactions between participants and the research they support, be it through more direct return of results or through a more general engagement with research. And this leads me to the last project I'd like to present today, which is about the role of the media in scientific literacy and the critical role it may play in the public's understanding of research they may be contributing to, as well as of their own research results. We looked at the policy messages about epigenetics in the national press in several IHEC member countries and did a case study of the evidence supporting policy messages about changes to parental responsibilities. Examples of some of these messages are shown here, such as only mothers have the power to change the evolution of obesity. We found a hyping of the scientific research results, not only in the news stories with these messages about parental responsibility, but also in the primary research publications from the scientific community. And so we worked on a template for press releases that could help researchers make their research limitations and important caveats about the interpretation of epigenetic results more obvious to the media. And to finish, I'd just like to mention the most recent work we've done with IHEC to consider ELSI challenges with the current interest in the study of epigenetic vulnerabilities amongst populations. This work was led by Katie Saulnier and should soon be published. I want to thank very many collaborators with the Global Alliance for Genomics and Health, the International Human Epigenome Consortium, and the Canadian Open Neuroscience Platform. And in particular, the McGill scientists and ELSI researchers who supported my work, Professors Bartek Knoppers, Jan Joly, Tomi Pastinen, Alan Evans, and Jason Karam-Chandani. And I look forward to discussions at the symposium.
Thank you so much for that, Stephanie. And I'll ask the panelists to turn their cameras on, if that's all right, so we can all have a look at you. And I'll open the floor to any questions. I have some of my own, but I'll step back and let any of the attendees ask questions if they'd like to. No, it doesn't look like it. I'll start it off then. Dr. Dyke, I was really interested in that second to last slide I think that you had up on epigenetic vulnerability. You put it up just as a little teaser, really, and I was quite keen to hear a bit more about that project.
Yes, thanks for the question about that. It's hopefully will soon be published. So I don't want to say too much because the researcher who led that work, Katie Saulnier, would be best placed to discuss the work. But basically, we looked at with epigenetics because of the potential impacts of and robust evidence that may be coming about epigenetic imprinting of social effects and potential vulnerabilities for populations. We thought it was important to start thinking about, because we are seeing more and more science focusing on these areas, how it could affect many of the issues that Professor Craig raised in his presentation about reinforcing stereotypes, leading to a somatization or a medicalization, I'll say, but I mean more like biological, I don't know what the word would be, of the social for these communities. So we looked at autistic populations, where there has been a lot of epigenetic research has been focusing, Indigenous populations in Canada, and transgender populations. And the key balance I think that came from this work is how to ensure that these populations are not excluded from research, because it will be so important for the benefits that could result for them, as well as a lot of evidence about potential impacts of the social on their biology. So how to ensure inclusion without without having some of the negative consequences that could come in terms of the treatment of these populations. So yeah, I'm hoping it will be. It's been submitted for quite a while. I'm hoping it will be coming out soon, this publication.
Thank you so much. Hi, Evie, did you?
Yes, I've turned my camera on so that I can say thank you to all the speakers, fantastic talks, and just welcome to everyone that's joined us since we started in this session as well. So it's been great to have some more people pop up in our attendees as well. I thought it was absolutely fantastic that the speeches kind of intersected on points mostly about social harm. So as we develop this technology, we've got the potential of causing greater discrimination, or, you know, feeding into medicalization, as we've heard. So I guess my question is, what sort of practical solutions do we have for this? Do we actually want to prohibit the development of certain sort of tests if they have the capacity to exacerbate that sort of stigmatization?
I have a quick comment. One of the big issues that I see is that for a lot of the concerns with genetic research, the laws have tried to address in many places and are, you know, very successful in providing protections around genetic discrimination for epigenetic results, data, and potential discrimination. It's a stretch, and it's absolutely not clear that the genetic non-discrimination protections will apply and will protect participants in the same way. So that's a big concern that I see.
It's an interesting question that you pose, Evie. It's I guess I should maybe use an example of the field of genetics of intelligence, which has led to, I think, a US-based company offering prenatal polygenic risk score testing of early embryos for intelligence. That's gone somehow out of the blue, but I think the onus is on researchers studying things like genetics or epigenetics of phenotypes that are potentially controversial to offer tests, in that I think the onus is on them to be more responsible in discussing their studies and the potential consequences. There was one GWAS of intelligence released from an Edinburgh-based group, and they produced a whole set of FAQs to go with their paper. So they were taking some responsibility with the way it's interpreted. But I think what I'm talking about is going beyond that, is to go further, not just how it's interpreted, but whether it should be tested for or not. And so if researchers within the field speak out on this, and also advocacy groups are invited to speak out, and it's great Stephanie was been talking with these representatives. If they, I was just thinking the other day, could a support group itself call for recommend a moratorium on direct-to-consumer tests for a particular disorder? I think we should explore those possibilities. On one hand, it sounds too prohibitory, but I think it's a matter of whether these issues should be discussed within the research and patient populations.
Thank you.
And Dr. Slockenberger, I had a question for you. I had a couple of questions for you actually, but I'll start with one. So of course, one of the dangers, as we've heard throughout the symposium, of genomic research is the risk of deepening health disparities. And in the case that the ban on human germline editing is lifted, what measures might be put in place to ensure equitable benefit arising from these technologies?
Thank you so much. This is a very good, but at the same time, extremely difficult question. If we look at the European countries, health policy design is the member state competency, and that applies across the world where the regional powers haven't been taken over. It's addressed as locally as possible. So for them, they would need to prioritize and think through, how do we make sure we enable access of the technology to the population groups that are needed? But the way forward would be to have adequate regulation in terms of public health care, so that the new benefit that would eventually be available then is accessible also.
Yeah. So leaving it essentially to the states to ensure equitable access to healthcare.
Exactly. With new medical interventions, we get also a question of intellectual property. And intellectual property rights, to the extent they come in, they risk placing certain societal groups in certain countries at a disadvantage. So we need to have a little bit broader discussion there on how to think about those health systems that might have more difficulty to ensure access to the new interventions.
Thank you. And my other question to you was, in the event that the European Union and the Council of Europe do lift the ban, member states would have a range of national legislation to permit such activities to be carried out. So I was wondering if you could comment on what would need to be done to bring that national legislation in line, the national legislation of member states in line with conditions needed to allow for human germline gene editing.
Thank you so much. It very much depends. If we look at the European Union situation, the central question is, what is the EU regulating right now with its clinical trials and the scope of the legal framework? And there we have huge question marks. We have this beautiful ban in clinical trials regulation, but at the same time, we know clinical trials apply to medicinal products. And the EU has been rather conservative in how it's defining medicinal products, and it has excluded a number of interventions from falling within the scope. Now, gene editing would fall into advanced therapy medicinal products. But even there, we are discussing that only some of the interventions could fall within the scope. So one question is of the effect lifting. The EU is not regulating technology as such. It's regulating the technology insofar as we are talking about clinical trials. So it would fall on the member states if the ban is lifted, insofar as the EU now has regulated it. One can draw the distinction between clinical care and enhancement in theory. In practice, it's very difficult to be drawn. And at least what we are discussing right now in Sweden is how to rethink the existing legislative framework in order to adequately protect people. Because we're talking on the one hand about accessing scientific benefit eventually, if that is safe and effective and in line with principles that we cherish, but on the other hand, we want to protect the society. And it's very difficult to find a good balance when the state should intervene and say, these are the conditions under which you can access the technology, and this is where we step in and say that this is dangerous for society, and here we set very strict conditions for access if there should be any access at all. So those are considerable discussions one needs to take if the decision is to allow human germline gene editing on top of implications such an intervention brings along for the humanity.
Thank you. Thank you so much. And any questions from the attendees? Okay, I get to throw all of my questions at the speakers in that case. Professor Craig, my question to you is along the same lines really as the one that I had for Dr. Dyke. So under social issues, you mentioned reducing complex social problems to molecular codes. So really, it sounds like you're pushing it back. You're pushing back against the idea that epigenetics could be used to illustrate the impact of harmful social environments. And I was wondering if you might be able to just expand on that point.
Yeah, I think it's looking at, in one way, it's looking at just one component of what the person is. I guess it's parallel to the description of what a person's health is and what a person is that the Indigenous people were talking about this morning. They're a lot more. You're a lot more than your genetics, and therefore you're also a lot more than your epigenetics. It's a view. It's a kind of. It's a medicalization, but it's more a molecularization that you're saying that your epigenetic state defines you. And again, there is people with a disease or disability often refuse to let their disease or disorder define them. So that's another. I think that's a parallel issue. Is that part of it's part of your identity, but it doesn't take over. You are not an epigenetically defective. You are a human being with a disorder that has an epigenetic correlation. And I think there's a spectrum of how you view yourself as an individual and how others would view you. We haven't actually. It's interesting. It's an interesting issue that we haven't really explored in detail. You've made me think I should go back and discuss that more with my colleagues. It does make you think, doesn't it?
Yeah, and I think that you're right that these are questions that were that have strong connections to the discussions that we were having earlier as well. Dr. Slockenberger, did you have a question that you wanted to ask?
Yes, it's been exciting to listen to the presentations from the panelists. And my question is to Dr. Dyke. You talked a lot about data sharing, and now with the thought of, or we know that data protection requirements have in certain regions across the world accelerated quite rapidly. How do those requirements relate to epigenetic research, and do they facilitate, do they set hurdles? What is your take on the situation?
I think really, as for any science, the data sharing, for the scientific applications and use is absolutely essential and a no-brainer. It's still very, very difficult to achieve culturally within the practice of science. For epigenetic data, because it is sort of falls in some way under the realms of genomic research funding, and the structures and the communities overlap, do overlap largely. the expectations, especially for the large scale sort of mapping initiatives, and to try to have a strong foundation for epigenetic, smaller epigenetic studies to refer to larger reference epigenomic data sets. The data sharing is absolutely in place, as it would be for genomic research, and even just the types of data, it fits very well with the databasing infrastructure that has been set up for genomics and so on. But the issue, as I mentioned, the legal protections are not there the way they are for genomics. They're still not as widespread and as robust as it would be nice to have them for genetic information, but for epigenetic data, it's even more it's even more risky. It's absolutely unclear what legal protections might be able to resolve in terms of the risks. The scientific community generally has been managing most of the risks through administrative and the exchange practices, because even though genetic non-discrimination legislation has come in the last sort of decade in many parts of the world, it's certainly not everywhere, and the idea was always to share internationally. But again, there's only so much that administrative and technological protections can do. So things need to be pushed at every level, and societal understanding and protections for the results of this research are going to be as critical. That's why the study of the role of the media and what the messages around this scientific information are, I think, is so important to the bigger picture of how society responds to scientific developments and treats people in consequence.
I also have a question for Stephanie. I was just thinking about how you were saying you were saying that you could remove identifying genetic sequence from the epigenetic data. Can you elaborate a little bit on how you propose to do that?
That work was for one type of it was for methylation data of a certain type, and I wouldn't be able to go into the because I collaborated closely with a scientist on that method, and but the idea was to remove the methylation data that provided genetic information, so germline genetic information from the subjects prior to sharing the data. And what's worth saying about that project is that we could only make that work because scientifically, for the use of the data, it was advantageous for the epigenetic analyses not to have that potential confounding genetic information, because this is always a big part of any of the discussions around what can be removed. And for example, with genetic sequence information, that data is unique and could potentially lead to re-identification, but that is the data that's needed for the research, so it has to be shared. It's riskier, and the protections have to go with that. Because this methylation data for analysis purposes, it made scientific sense if it were to remove the genetic, let's call it contamination. That was something that was acceptable to the scientific community. The genetic information could be filtered out and it could be shared that way. Other types of epigenetic data, I'm sure, might also have identification risk as well as potentially genetic information with it, and whether or not for different data types, whether or not it's worth de-identifying the raw data, the source data in that way, will be something to be assessed. So it can de-risk, or there can be additional protections provided through the administrative data access models and other procedures. But generally speaking, it's extensive, potentially identifiable, potentially very sensitive data on individuals that's being shared, and it needs to be done very carefully, and people need to understand how it's being used and what the risks are. One thing I do want to say as well about genetic information, although it is highly unique and can be identifiable. Unless there's genetic information about you or about your relatives that's available, it's not that easy. And typically, if somebody already has that information about you, well, it might not be such a concern that they're going to find your research data.
I think that's a very interesting. It's a very good point. I think it's a really interesting way to MGD identify. And I think there are locations in the genome that are, I guess they're called methylation quantitative trait loci that are strongly influenced by genetic sequence. And I can see, tracking back, could look by looking at the absolute value of DNA methylation at that spot, you can probably work out what the sequence was. And if you add all those up within the genome, you could quite quickly get a match, as you said, if you have that sequence.
And thank you so much for that, Stephanie and Jeff as well. And Sandra, I think that you'll have the last question. We are running a little bit over time, so we'll make this the last one.
Okay, thank you so much. It will be a very short one to Professor Craig. You mentioned different applications of epigenetic testing, and one of the tests that caught my attention was regarding epigenetic age. And we had quite some discussions a while ago, 2015-16, in several European countries about the methods that could be used in order to identify age of persons in a very reliable way. And then there were significant scientific discussions whether the results we got are accurate. So I wonder about this epigenetic testing for age. How reliable is the test and the result that we could get? And whether that could then help us to base legal decisions on whether the person falls into the child or adult group and the different protections people have.
Sorry, you're muted.
Oops, sorry. I think that with the various different epigenetic plots that have come along, they started out with an accuracy of ±3 years, and I think they've gone down to ±2 years, and some are even claiming less than 1 year. But really, if you're talking about one individual, then there's a huge potential to get an inaccuracy. It's the same for polygenic risk scores as well. Within a population, fine, you might see a nice stratification. But say we're talking about somebody, say if there's most of the time you can look at within even 1 year either way. That's still a 2-year period. And say if it's somebody that's claiming to be a minor and they may be 1 year older or younger, and if you can't be really certain of their precise age, then I think it's not that reliable. I think if it was 5 or plus more years, younger or older, then that might be more reliable. But I think with these, like all these tests, the research needs to be done. And it needs to be done not just with the data sets people have, but new data sets, blind data sets. What proportion of people in a situation like this, imagine it's less than 18, you give the researchers a whole lot of DNA samples from people ±5 years within 5 years of age 18, and they've really got to show you that there's a really high probability that you're being accurate. And these kind of figures, when generated, presumably could potentially be used in legal situations. But I think that there needs to be a lot more research in the real world, so clinical trials, if you will.
So as I said, we are running a bit over time, and thank you so much to our speakers, not just for this session, but the two before as well. It's been such a privilege and such a fantastic opportunity to host all of these really wonderful conversations. And thank you so much for contributing your time and your expertise, and to the attendees as well. I know that it has been a long day or a long couple of days for some of us, so particularly to the attendees that have stuck with us for the three sessions over various time zones. Thank you so much. It's very much appreciated. So thank you so much to all of you.
Thank you very much.
Angeline.
Thank you.
Thank you for organizing it. It's gone
See you at
really
the
well.
round table.
Of course, I'm sure we'll be in touch soon. Thank you so much.
Okay, see ya.